Now, to the top story. The middle of the night, news broke. Sudden change in the case against Bryan Kohberger. There was supposed to be a preliminary hearing. It's where the prosecution comes out and lays out why they have the first hurdle of proof to charge, which is probable cause that a crime has been committed, and it is by you, the defendant, in this case, Bryan Kohberger. This is very important, not just for the criminal justice process, but for the defense. Why? Because they get a bite at the apple of understanding what's coming their way and why prosecutors think what they think. Instead, there was a grand jury convened, and the grand jury handed up an indictment against Kohberger on 4 counts of first-degree murder, so there will be no preliminary hearing. 4 counts for first-degree murder and burglary. Why? We'll discuss, but the short answer is prosecutors do this. They layer charges. You went into the house without invitation. That's trespass in a home. That's burglary. And then you killed people. So just in case they don't get him on the murder charge, they have the backup of the burglary charge. Very different charge, not as much time, but it can carry significant time. So it's a way of safeguarding themselves, bootstrapping their case. So the question becomes, why the change? Was this about information or evidence that compelled prosecutors to do it this way? Or is it just a tactic? The indictment means the grand jury determined there was enough evidence to convict him, probable cause. So is there new evidence, or is this just a way of getting it done without a preliminary hearing? And why would prosecutors want to do that? Let's bring in the better legal minds to discuss. Former FBI agent Jennifer Coffindaffer, high-profile defense attorney Mark Geragos, Florida State Attorney Dave Aronberg. It's good to have the dream team here. Coffindaffer, in making cases, what do you sniff out here? Is this about something new, or do you think this is about what prosecutors just wanted to do, and if so, why?
This is a great strategic win for the prosecution. They made the right choice here. I think this grand jury was convened some time ago, and they've been looking over the evidence, and it just so happens this is the date it came up. But this is something that blindsided the defense, certainly, just as it blindsided some people in our audience and us, possibly. We always thought they should go to grand jury, and they did.
Mark Geragos, I hop to you as being on the defense side of the ball. Why do you like when there's a preliminary hearing, and what do you think of this change?
Well, what you love about a preliminary hearing as a defense lawyer is you get cross-examination of the witnesses. The difference, they're both probable cause proceedings. The grand jury is a probable cause proceeding. The preliminary hearing is. The main difference is that when you go by way of a grand jury, you eliminate those pesky defense lawyers asking your witnesses questions or challenging the evidence. You get basically a loaded deck if you're the prosecution. You had said something in the setup, and I don't know the answer to that. There are jurisdictions, I mean, in federal court, you almost never get a preliminary hearing. It's almost always by way of a grand jury indictment. In California, it's quite the opposite. In state court, you almost always get a preliminary hearing and not by way of a grand jury. I don't know what the culture is in Idaho, but if the defense was unaware, or to quote Coffindaffer, if they were blindsided by this, then that speaks volumes as to what the prosecution's motivations were.
Dave Aronberg, does this lend the possibility that prosecutors did not want their proof tested any more than it absolutely has to be, and that's why they went this way, so that this is somewhat of a vote of no confidence in the case?
No, Chris, I always wondered why prosecutors just didn't go to the grand jury, why they even entertained the idea of a preliminary hearing. It serves them no purpose. It allows the defense to see the prosecution's hand. Also, remember, there's the interesting issue of Bethany Funk. She was the witness there who the defense subpoenaed to appear at the preliminary hearing, and she didn't want to testify. She wanted to quash that subpoena. Well, now that's all moot because there will be no preliminary hearing. So having a preliminary hearing only helps the defense, and that's why I expected this day to come. I just didn't know when.
Hey, thank you for watching. Please go to newsnationnow.com, newsnationnow.com, and you can find NewsNation on your television provider. And don't forget to click the red subscribe button down below. Then you will get more of NewsNation's fact-driven coverage.